Section 12, Legal Hotline Q&A, Part 3, Today's Fair Housing Rules and Regulations, 2026 Standard. Introduction, Mastering the Final Layer of Real-World Compliance. At this point in the course, you've built a strong foundation. You understand fair housing laws, how discrimination happens, how to respond in real time, and how ADA compliance impacts accessibility. Now we step into the final layer, Advanced Real-World Application. This section builds directly on Sections 8 and 11. You are no longer just identifying violations. You are now expected to anticipate them, prevent them, and navigate complex gray areas with confidence. These legal hotline scenarios represent the types of issues that even experienced agents struggle with. The difference now is that you have the knowledge to not just react, but to lead with compliance. Scenario 1. HOA pool restrictions and familial status. Let's start with something that seems simple, but is actually high risk. An HOA creates a rule. No one under 16 may use the pool unless accompanied by an adult. A 13-year-old is denied access. Is that enforceable? Probably not. The Fair Housing Act protects familial status, meaning families with children cannot be subjected to unreasonable restrictions. While safety rules are allowed, overly restrictive rules that limit access to amenities may be considered discriminatory. 2026 Insight policies must be reasonable and applied equally, not restrictive in a way that targets families. Scenario 2. Equal housing logo in advertising. Now let's revisit advertising, one of the highest risk areas. An agent wants to run a newspaper ad but isn't sure what size the equal housing logo should be. The answer? HUD provides guidance based on the size of the advertisement. Larger ads require larger logos, and smaller ads may use the equal housing slogan instead. Real-world application. This ties back to Section 6 and Section 7. Advertising must clearly communicate equal housing opportunity. In 2026, this extends to social media, online listings, digital ads. Scenario 3, Disability and No Pet policies. Let's go deeper into disability protections. An individual with AIDS is emotionally attached to a small dog, but the community has a strict no pets policy. Can the rule be enforced? It depends. If the animal is necessary for the individual to have equal enjoyment of the property, it may qualify as a reasonable accommodation, and the rule cannot be enforced. If it is simply a preference, the rule may stand. Key takeaway. Not all requests are automatic, but all must be evaluated carefully. Scenario 4. Assistance animals and deposits. Now let's remove the gray area. A tenant has an assistance dog. The landlord wants to charge a pet deposit. Is that allowed? No. Charging a deposit for an assistance animal is considered discrimination because assistance animals are not pets. They are necessary for equal use and enjoyment of housing. 2026 reality. This is still one of the most common violations in property management today. Scenario 5. Disclosure of a halfway house. Here's a tricky one. A listing agent discovers a halfway house for recovering alcoholics next door. Should they disclose it? No. Recovering alcoholics are considered disabled and are part of a protected class. Disclosing this information could be considered discriminatory. Tie back to Section 3. Discrimination is not just about denying housing. It also includes sharing information that could influence a buyer's decision based on protected classes. Scenario 6. ADA compliance in commercial spaces. Now let's combine ADA and fair housing. A commercial office building has a bathroom door too narrow for wheelchair access. A disabled employee cannot use the restroom. Who is responsible? Both the landlord and the tenant. Under ADA Title III, both parties share responsibility for ensuring accessibility, and barriers must be removed if it is readily achievable, and widening a doorway is generally considered achievable. 2026. Insight. Accessibility is not optional, and responsibility cannot be avoided through lease agreements. The pattern, advanced compliance awareness. At this level, you should notice a pattern across all scenarios. Policies must be reasonable, protected classes must be respected, accessibility must be addressed, advertising must remain neutral, disclosure must avoid protected class information, and most importantly, you are responsible for recognizing these issues before they become violations. The 2026 professional standard. Today's top agents don't just avoid breaking the law, they educate clients proactively, question policies that seem restrictive, recognize subtle discrimination risks, apply both fair housing and ADA principles together. Because at this level, compliance is not reactive, it is intentional and consistent. Online discussion. Question 1. Why can HOA rules create fair housing violations? Answer. Because overly restrictive rules may disproportionately affect protected classes, such as families with children. Question 2. What is the difference between a pet and an assistance animal? Answer. An assistance animal is necessary for a person with a disability and cannot be treated as a pet under fair housing laws. Question 3. Why is disclosing certain neighborhood information risky? Answer. Because it may reveal the presence of protected classes and influence decisions in a discriminatory way.